Welcome everybody. My name is Fiona Kelly and I am the Dean of the La Trobe University Law School, and it's my great pleasure to welcome you all to today's event. I want to begin by acknowledging that I am currently located on the unceded ancestral lands of the Wurundjeri people of the Kulin Nation, and I pay my respects to their elders past and present, and I particularly welcome any First Nations people joining us today. So today's event has been made possible by a number of hosts, starting with the Victoria University College of Law and Justice, the La Trobe University Law School, and the Law and Society Association of Australia and New Zealand. We're very lucky to have some wonderful speakers today, and so I will now pass over to Dr. Bill Swannie from Victoria University, who will introduce our speakers and the topic. Thanks, Bill.
Thanks very much, Fiona. I'd also like to acknowledge that I'm on the lands of the Wurundjeri and Woiwurrung people of the Kulin Nations, and I pay respects to their elders past, present and emerging. The panel discussion today will focus on anti-vilification laws in Victoria. These laws are sometimes called hate speech laws. The discussion today will examine the laws that we have, some recent changes to these laws, and what we could possibly have in the future. This event today is proudly presented by the Law and Society Association of Australia and New Zealand, and it's supported by Victoria University and by the La Trobe Law School. I encourage you, if you're not currently a member of LSAANZ, to go to their website and join LASANZ, and you can enjoy similar events to the one which we'll have today. The event today will have three parts. Firstly, I'll introduce the panellists and briefly outline recent changes to anti-vilification laws in Victoria. The second part, I'll ask some questions to the panellists about these laws and the recent changes. And finally, the panellists will have an opportunity to respond to the questions which you've asked through the Q&A function. So to move to introducing the esteemed panellists which we have today. Fiona Patten MP is a member of the Legislative Council of Victorian Parliament, and she has been a Member of Parliament since 2014. And relevantly for our purposes today, in 2019, Fiona introduced a bill to reform Victoria's anti-vilification laws. Nyadol Nyoun OIM is an Australian lawyer and a human rights advocate. She is the director of the Zelman Cowan Centre at Victoria University in Melbourne. Nyadol was born in a refugee camp in Ethiopia, and she is a prominent anti-racism campaigner. Nyadol was awarded a Medal of the Order of Australia in 2022 for her service to human rights and to refugee women. And finally, Liam Elphick is an Associate Lecturer in the Faculty of Law at Monash University, and Liam is a leading expert on the intersection between LGBTIQ+ rights and religious freedom. He is a member of the Australian Discrimination Law Experts Group, and he has made written and oral submissions to the Victorian Inquiry into anti-vilification laws. I want to thank the panellists for today, and we're aware that Fiona will have to leave at 1:30 today. Just a brief outline in terms of anti-vilification laws in Victoria. Victoria has had a Racial and Religious Tolerance Act since 2001, and these laws contain civil and criminal provisions, but there's been only one criminal prosecution and only two successful civil cases since these laws were introduced over 20 years ago. And in 2019, Fiona Patten introduced a bill to reform Victoria's anti-vilification laws. This bill sought to extend these laws in two significant ways. Firstly, the bill would extend the laws beyond racial and religious vilification to also include vilification on the grounds of gender, sexual orientation, gender identity, sex characteristics, and also disability. And secondly, the bill would regulate online vilification much more effectively than existing laws. In late 2019, the Legislative Assembly referred an inquiry to the Legal and Social Issues Committee regarding the effectiveness of Victorian laws and possible extension or expansion. The report was tabled in March 2021, which made several recommendations for reform. And in 2022, in this year, most recently, Victorian Parliament passed laws enacting one recommendation made by the committee, And these laws, which commence on the 1st of January next year, will create a new criminal offence of banning the public display of the Nazi swastika, subject to certain exemptions. And I'll now turn to the panellists with some questions about the vilification laws that we have. So the first question is, why do we have anti-vilification laws? Why are they important? And I'll throw this open to any panellist.
Let me start, I suppose. I think one of the important reasons for me is that quite often vilification is a precursor to violence. And so by establishing anti-vilification laws, we can hopefully stop actual assaults from happening, because as we know, vilification is about inciting violence. So by preventing that incitement, one hopes that we can prevent violence. And I think the second point, which was certainly one of the motivators for me in the legislation, was the silencing effect that vilification has on people, that people then remove themselves from those public spaces because of the attacks that they have received and the threats that they have received and the type of vilification that they've received.
Maybe I'll jump in. I think the question itself reveals a tension in what is generally a democratic society, where you've got freedom of speech on one hand, the ability for people sometimes to even express opinions that you might fundamentally disagree with. So you've got a tension between freedom of speech and to some degree where we draw the line, where that speech is no longer conducive to a social cohesion, or in fact, in most cases, become incitement to violence. And I think generally that's a very hard line to draw. And their clear statement that incite violence, that might be easier to regulate or legally term as unacceptable in some form. But then there are also a lot of gray areas about offensive,ness or racist attitude that don't amount to an incitement of violence. So I think that the reasons why we need anti-vilification laws is because there is sort of harmful language precedes harm most of the case. And there's a book called written by a philosopher called Dehumanizing inhumanity, or less than human, and it talks about this idea of how almost every stage of genocide or mass violence always start with a campaign of dehumanizing people and using language that other them so much that it justify the violence that then follows through. I suppose the way I reconcile it in my head is that there are societies, for example, Germany, and it has a very specific history that have made these very clear lines between hate speech and sort of free speech. And those countries have not collapsed as liberal democracies because they've been able to make those distinctions. So I think we can be able to make those distinctions. I think there are difficult distinctions to be made, and there is space for more public debates about where do we draw those lines in society, especially like Australia, that is multicultural. Where do we continue to draw those lines legally, and as we become a much more, I suppose, inclusive, or if we're going to become a much more inclusive society.
And yeah, if I can just add too, I mean, unsurprisingly, I agree with everything Fiona and Nyadol have said there. And I think in addition to it inciting violence, I think even the harm of hate speech in the first instance is one we need to address. The preamble to the Victorian Racial and Religious Tolerance Act actually says that vilifying conduct is contrary to democratic values because it diminishes dignity, sense of self-worth, and belonging to the community. And so I think even where it doesn't, for instance, lead to those situations of violence, which should rightly be our number one concern, the other concern is in the first instance that hate speech can especially diminish people's dignity. And we see that vilification quite clearly targets particular communities, which we're going to talk about today, and often those communities are more marginalised and vulnerable to this type of speech.
Thanks very much for all your responses to that question. And the question I want to move to now is, what changes do we need? Like, what changes are needed in relation to Victorian anti-vilification laws? Like, how could the laws be improved?
Well, I would certainly suggest that the bill that we put forward in 2019 provided one avenue for improvement, and that was to broaden the protection of our anti-vilification legislation, as you mentioned at the top bill, to people with disability, to on the grounds of gender, on sexuality, on characteristics, and we know right now that many people are experiencing vilification online in particular, and it has had some really significant consequences to people's lives. So I certainly think that is a good area. I also, maybe when you look at the prosecutions, the successful prosecutions that we've had under our legislation, that maybe we do need to consider the extremely high bars that we put in place for vilification. And certainly my bill did look at tempering, at changing maybe where that bar was, that the person didn't have to know, but that the action was likely to incite hatred and violence. So I think, yeah, changing the bar, but also broadening the protection to include other groups.
I think that's a I would say definitely online seems to be a place where anti-vilification laws haven't really caught up, and perhaps and even if they were to, it's a very hard space to see how conduct online would be regulated, just because of anonymous trolls, but also the fact that you could get someone from, I don't know, South Sudan abusing you and you live in Australia. Like, how do you actually enforce such laws? Become very, very difficult. But that's, I mean, but that's a space that I don't think we would have the luxury of ignoring. More and more of our life is now online, and it's going to have to be a legislative concern about how online spaces operate and how people are affected there. So I think that's the first part that I think the laws could be extended to. I think that we do have, though, sufficient laws at the moment that are don't appear to be used, either because the bar is too high to prove the particular conduct in court, also because some of the most of the victims of vilification tend to be the kind of people that might not necessarily want to litigate. You know, they come from some of the most disadvantaged communities, socially, politically, and otherwise. So that puts in a barrier. So we need more lawyers, and I think that more lawyers or community legal organization, and I know they're so underfunded to even mention that, but to be able to try and test out these things in court, we need to be able to get lawyers who can test these things out. So we know, we begin to have a body of knowledge and understanding about how our laws will approach these issues. Whether it's, in fact, it's prosecutors being able to add it on to aggravating factors. You know, I remember in the death of Liu Goy, who was a young South Sudanese boy bashed to death by two young white men who say they were going out looking out for a black man to kill. You know, and not only did the hate crime aspect of the matter not get heard, the judge herself expressed, in my view, you know, quite an awful limited understanding about how racism operates. So I think that also brings in the question about the institutional decision makers that we have, who might come from a class of people that don't experience the kind of vilification that the people that are judging experience. So there's a question also of the competency of and I have to be careful as a former lawyer, and maybe going back one day of passing judgment on judges. But I think we admit that we lack the diversity in the legal profession across the board to be able to identify these issues as real social concerns that requires a judicial response of some form or a legislative response of some form. So I think that's another challenge. But I still maintain that any changes that comes in has to be carefully considered, because freedom of speech is an important civil right, and even as a person who has experienced racism and vilification, I understand that the democratic project requires sacrifice from all sides, that at some point there is something that I must be willing to live with, even if it's not good for me, because it's good for the democratic exercise that we're all engaged in, right? So I think it's an important conversation that has to be sensitive and practical. So I think that's why, in some ways, the introductions of banning Nazi artifacts was a good timing, because it came at a time where Asia was telling us that we're seeing a rise of extremism online, that we're seeing a rise of the radicalization of young men, particularly teenage young men. It came after they had protested in public or held like a Nazi rally in public. So these were there was a condition that justified the introduction of those laws, and perhaps that's a model of how to approach it, because you also don't want to undermine the principle of free speech as well.
Yeah, similarly for me, I very similar ideas. I think of it as probably three main ways in which we can improve vilification laws, not just in Victoria, but across Australia. I think the first is breadth, and Fiona's bill goes to that quite clearly around the attributes through which we prohibit vilification. Historically, across all the Australian jurisdictions, racial and religious vilification have generally been prohibited, but at a general level, the other attributes tend not to be. And obviously, racial and religious vilification are significant problems, but so is sex and gender-based vilification, and so is LGBTIQ vilification and disability vilification, amongst other groups. And so broadening vilification laws to protect attributes similar to how discrimination laws protect attributes would be a big first step. And I think Tasmania has roughly 22 or 23 attributes protected in its discrimination law, and 14 of those it also prohibits vilification on the basis of. And yet in Victoria, we just have 2. So, actually going even further and assessing which other attributes we should be protecting doesn't mean it's all of them. There might be reasons, for instance, you don't prohibit vilification on the basis of political belief, and some other ones that maybe where that line that Nyadol was talking about doesn't quite operate in the same way. But certainly the attributes in Fiona's bill make all the sense in the world to me. Disability, LGBTIQ attributes, and sex or gender. The second thing to me is enforcement. We have vilification laws that were created in Victoria 21 years ago. They're not built for social media, obviously, because they weren't in an age of social media. If you wrote these laws 10 years ago, they wouldn't be built for social media and the sort of harms we're seeing occur now. So we need better enforcement mechanisms to allow tribunals, courts, equality commissions and other bodies to, particularly on social media, unmask those who are engaging in this sort of trolling and this sort of vilification online, and ensure that we can actually find these people and then hold them accountable. Because often you'll see with instances of trolling or social media abuse, you just can't find who the person is. So if you can't find who the person is or know exactly who the person is because they're hiding behind perhaps an anonymous account or some sort of other marker, then we can't resolve that through the vilification law provisions we have. We can't bring a claim against no one. We need someone there. So actually providing stronger enforcement mechanisms, again, as Fiona's bill does, would be a big step. And I think the third thing to me is awareness. I'm always struck by the fact that in Victoria, vilification laws have almost never been used. Like, there are a handful of instances in which they've been used, even fewer when they've been used successfully. And so some of that, no doubt, is in part to the fact that the laws are harsh and difficult to succeed through. I think another part of it is we've done a pretty good job of raising awareness and understanding and education of our obligations under discrimination law. I'm not sure we've done as good a job in vilification law. And maybe it's because of the free speech aspect that we've been talking about that makes it trickier. The competing rights aspects, I'm not exactly sure, but it strikes me that we don't have as much awareness of that. So whether it's an education campaign, you know, through the changes that are going to occur in Victoria, post-election, I suppose now, and the changes that have already been made around Nazi symbols, something around that to actually raise awareness of how these laws can be used and making sure it's easier for people to understand and use them through our existing processes.
Could I just jump in, because I think you mentioned the kind of the context. I think the other context that makes it harder beside free speech is the current social discourse that we're having, the cultural wars that we're currently having, that makes it very hard to be able to have any sort of intelligence debate about where to draw the line. And so you get people that conceived any attempt to limit free speech as a sort of woke and snowflakes and, you know, political correctness gone wrong. So you've got that, you've got the sort of the cultural war dynamics that is exacerbated by certain media organizations. And I think you add that on with politicians willing to engage in very vilifying terms about members of communities. And I think that creates a toxic ecosystem for people to want to be able to engage with anti-vilification law, because a lawyer deciding to take on a particular case all of a sudden can become a crazy campaign that as we saw with the Human Rights Commission a while ago, when they took on a particular case around, I think, something that happened at a university, and it became a point of a cultural war that then was calling for, in fact, the abolition of the Section 18 of the Racial Discrimination Act. So you can see it makes it a very toxic environment to even consider utilizing those laws when you've got politicians as well as a process where conversations can't even occur in the first place.
And Bill, I think that goes on to that second question around why is it so difficult, and it's interesting. Like when we were putting forward our bill in 2019. You know, there was a lot of criticism, and it goes to a lot of the things that Nyadol was saying just now. However, there was no one calling for the repeal of the protections for race and religion. You know, that there was even the most libertarian of politicians was still supportive of there being protections against religious vilification or racial vilification. So I think it's interesting that they draw the line around gender, they draw the line around sexuality, and they draw the line around disability. But remembering that this is about inciting violence, you know, this is about actions. And, you know, going back to looking at what ASIO's recent reports and going back to actually my parliamentary inquiry into extremism, you know, we know that this type of language is very useful in recruiting for those organisations, and as you said at the start, Nyadol, like setting those people as other and furthering that otherness and that unhumanness of people. So we don't find it difficult to protect people on the grounds of race and religion, and I don't think it should be difficult to extend that protection to everybody who is experiencing vilification.
All right, thanks really much. And I want to move on now to talking about the role of the media. So talking about the traditional media rather than social media, and ask any of the panelists to talk about what is the role of the media in the context of vilification laws. Because we've heard a few panelists speak about free speech, and that's often through the vehicle of the traditional media. But what other roles does the media play in terms of the culture wars and the debate about vilification laws themselves?
I think I'm jumping on because this is something that has happened to me for a long time. I think the current Australian media plays a significant role in narrowing what is even possible to talk about, first of all, and what can government do. You know, I've worked even in government where people have said things like, oh, how is this going to look on the front page of the Herald Sun? So a matter for public policy now is being decided by the kind of coverage that it's likely to get. This is no longer a secret, right? I mean, you've got three past prime ministers, I think, Malcolm Turnbull, somebody else, two past prime ministers, Kevin Rudd, Malcolm Turnbull, and then I think, you know, a leader of the Liberal Party at some point, talking about how media told them, if certain media group told them if they didn't conduct their politics a particular way, they should expect a particular kind of coverage. So this is not, it's no longer a debate, it's no longer a secret that the media is confining the space. You know, at the same time talking about free speech, it's truly confining the space for what options become possible as a social priorities of any form. And then I think that the current media model, in my view, the business model has shifted vilification as a form of sustaining clickbait news, clickbait entertainment. So there is now an economic imperative to continue the vilification of certain groups. You know, so it's not often. You've seen campaign led against trans kids. You've seen campaign led, you know, around African gang. All of this starts off in the social media ecosystem, and not social media, in the mainstream media ecosystem. And I think that it has become, in my view, I consider it far more toxic and far more consequential than a random person on Twitter saying awful things. So I think when the mainstream media is a tool of vilification. We've seen people hounded out of this country because of something that they have said, and or politicians being pushed to positions or criticized into a position if they take, you know, a position that doesn't align with this media organization. I see them to some degree almost as if they've become a PR, you know, a PR piece for vilification of minority groups and vulnerable groups in our society. So I don't think solutions is coming from.
If sorry, I have to go, but if I could just add a contrast to that, in the consultation around developing the vilification bill that we did, it was actually journalists who contacted us because they had experienced that vilification. So particularly for female journalists, like, it was really that cohort of people just really experienced vilification like nothing else that their peers, that their male colleagues had never experienced. You know, the attacks, and I think of sports journalists who were just, you know, attacked online to such a degree, you know, and then, you know, their families attacked. And so I think the media can be part of the solution. And you know, I certainly, you look at things like the African gang campaign that Herald Sun was complicity in. Absolutely, it failed miserably electorally. They, you know, that the party that ran with that could not have done much worse at the election as a result of it. So you know, maybe they shouldn't be listening to the Herald Sun for their PR, for their election campaigns.
That's, you know, I think I mentioned before the story of the boy of Leo, and I know, and it's still quite, to me, saddening that it's not a very well-known story in Australia. You know, the two young men that went out and looking for a black guy to kill and found Leo and bashed him, literally bashed him to the point that he was unconscious and his family had to remove his life support. You know. One of those young men who, you know, it's reported in the case that had taken a newspaper that had saying that had written an article about how Sudanese people were turning their town into the Bronx. There is a direct link, you know, between who media attempts to vilify and the consequences for those people. We saw it also in the marriage equality debate, right? Where that whole debate that was seen as a democratic debate or a debate that we needed to have, having real consequences for people's mental health and well-being, and the same thing with the African gang. We saw tremendous rise of suicide in our community. I mean, there was a point I attended 3 funerals consecutively for 3 months. Now, you will never be able, obviously, to say A linked to B, but it's also not so unclear that there is a link between the constant vilification of people and the way they experience life itself, the abuse they experience when they go to shopping center, the being spat on, the over-policing of this community, because now we are characterized as some sort of gangs, the fear that these people live with, and unfortunately, I don't see the current media model that has really embedded itself with the vilification of certain groups changing anytime soon. I don't see that happening.
And I want to come back to that point about online trolling. How could current anti-vilification laws, how could they regulate the online trolling aspect more effectively? Like what needs to happen to be more effective in terms of prohibiting or regulating online trolling?
I think there are a range of things, Bill, that probably relate to what we've already talked about. I mean, I'm struck by the definition that we have in Victoria currently, which really focuses on the response of the audience to vilification, to speech, as to whether it's vilification or not. And I know you've been a proponent, amongst many others, so I'm speaking to the expert here myself, of changing that to focus on the effect of the communication on the target of the speech. Because I think often we might consider trolling to not meet a threshold that currently sits in vilification laws. In Victoria, it's a really high threshold of hatred, serious contempt, revulsion, or severe ridicule. I mean, these are really high thresholds to beat, right? And Fiona's already talked about lowering the bar of those within her bill, but I think we can go even further and change the actual process of that inquiry to focusing on the effects on the people who are targeted, on the groups who are actually being targeted by this speech. That's what we should be focusing on, rather than on other audiences who might hear that as well. If we're focusing on the victims, as victims of vilification are in this space, then I think that helps lower the bar to make trolling something that can be addressed. But I think the other aspect goes back to what I said about enforcement. I mean, trolling is so often done either anonymously or by someone that's hard to find. We don't currently, I mean, this is across Australia, not just Victoria, have strong enough enforcement mechanisms to hold these people to accounts. And I know Fiona's bill puts forward some mechanisms to allow, equality, the Equal Opportunity and Human Rights Commission and VCAT to actually unmask those individuals and investigate into those individuals. But we need stronger powers across the board, not even just in vilification, but discrimination law more generally, to address trolling, because the problems we have with this occurring online is that we just can't figure out who should be liable in the first place, because so much of it is done by these, the burner accounts, as we see on Twitter especially. So to me, it would be about lowering the bar quite significantly, but also making sure it focuses on the right process, and then ensuring that we can then, once we've cleared that bar, actually allow the law to be used in the way it's used. But we should also recognize that all of this is just about law responding to instances of vilification. In an ideal world, we're also using the law to prevent vilification in the first place. And unfortunately, I don't think vilification law is a strong mechanism to do that as it currently stands. And we're a long way off using it in the way that we're starting to see discrimination law used, with positive duties to prevent discrimination before it occurs.
Yeah, and another question is, we often hear this argument that we don't need anti-vilification laws. Well, what we need is more debate or more discussion. And it's often said that the proper response to vilification is not to have laws or a legal response. It's for the vilified person or the vilified group to actually speak back to the vilification. How would you respond to that type of argument?
It's one that is actually quite common. This idea that there's a marketplace of ideas that these things can be thrashed out in, or there is in fact that sunlight is the best disinfectant. There's a variation of this, but I think a lot of it is, I was going to say bullshit, but I actually think it is. A lot of it is, because the first thing is that these conversations are inherently also about power. It's about who has the platforms. If you see the current Australian media landscape, as someone joked in a recent report that there's like a cartoonish cow more than you will see a person of color. So we're having this debate framed from the perspective of, always we're having this debate framed from the perspective of the person who have never experienced vilification, telling people who often experience vilification how they should respond to the vilification that he themselves don't even think sometimes exist. So I don't think that you can't talk about a marketplace of idea where the only people in that market are the people doing the vilification, or the people unlikely to suffer the vilification in the first place. So there's no diversity in the media or our parliament, or the various forms in which we can engage in this debate. The second thing is that we've been having these debates for a long time. If sunlight was going to be a disinfectant, it should have worked already. Like we've been having conversations about race and discrimination and abuse for centuries. The reason these things don't shift is because there is still power in using the tools to vilify people. It wasn't an ad hoc decision when the Liberal Party decided to use the African gang narrative. They knew that they were tapping into a lot of suspicion and fear and otherwise built into the different systems that could allow them to be able to use it and get away with it, or even get elected. We've seen it with Pauline Hanson. We'd seen it with the former what's his name? I think it was called Fraser Annings. So there is a benefit that is not to the vilified, but to those engaging in this type of vilification, that is worth engaging in, and therefore that's why it's not surprising that almost every election we go into, we know that there are going to be groups who are going to be highlighted as the thing we need to protect ourselves against, whether they're Africans or refugees or LGBTQ people. So I don't think that sunlight would ever change it. I think it's unfortunately always going to be a very slow push to ensure that all people experience the right and the protection to live a dignified life that is equal of recognition and respect. And until we as an Australian community are repulsed enough to never have the kind of Pauline Hansons in our system and the rest, it's a two-way question. It's not so much about whatever anti-vilification law we could do. It's the fact that the fact that racism and discrimination exists. It exists because those attitudes exist in our communities and will continue to do so for the foreseeable future.
And if I can just add as well to Nyadol's great points, I think the idea of speaking back sort of presupposes, an equal playing field in terms of power dynamics here. And often that's not the case. In fact, almost always that's not the case when it comes to vilification. And so it seems to me to presume that the only way to respond to that is to vilify them yourself, as opposed to there being no other way to respond to difficult discussions. I mean, the point of vilification laws, I would suspect, is that we're trying to ensure that robust discussion doesn't cross that line that Nyadol also talked about earlier, that there's a line there that we draw. It's not to remove the need for difficult, robust discussions. It's to say that, in engaging in those discussions, that should not, you should not be permitted to engage in racial vilification, in religious vilification, in disability vilification. That's the line we're drawing. So in terms of speaking back, I mean, I just think it sort of perhaps, ignores some of the more complex power issues going on and the need to protect the marginalized communities that are being targeted, rather than saying we need to give everyone a right to vilify everyone. I mean, I think of it as leveling up, not leveling down. That's probably my response to it.
I think at our point, it also treat vilification as just a matter of taking offense, right? It's just it's just your feelings. But there's really good research that shows the sort of the health impacts of being vilified in certain manners, like the real physical health impacts that come from it. I think in about 2019, doctors in the United States released a statement about how racism was a public health issue. So it's just not about just being offended. It has serious really consequences for the mental health and the physical well-being of people who experience this kind of contempt in their lives.
We've had a question from the audience, and the question is, it says, thanks everyone for the brilliant discussion. Does the panel have any suggestions how we balance the right to privacy with the need for greater accountability of online harassment and abuse? So I guess it's dealing specifically with the sort of one-to-one or the online, like how do we balance prohibition or regulation of that sort of speech with protecting privacy on the other hand?
I think that's a really good question. And I think probably that's one of the reasons why I am quite cautious about introducing laws that reveals people's identities online, because I think that like anything, that they have a potential to be truly exploited, and it can result in the exposures of the identity of people that are being targeted for nothing else than because they express a fundamentally different political position to say are politicians. And so one of the reasons I was quite hesitant when the federal government introduced the anti-trolling laws was because it looked to me as if it was just giving the powerful more power to discover who they didn't like online and to expose them and to therefore subject them to some form of litigation or other form of harassment. And I think that in the current context where we've seen a government willing to manage the scope of which they are criticized by the public, it is concerning if it's extended online. And for example, we've seen attempted laws that were being introduced in the not-for-profit sector that was couched in the language that it was about limiting their scope to doing certain activities, so that it was going to stop not-for-profit organization from political campaigning or political advocacy. And these laws were going to disproportionately affect, environmental groups and other social justice groups more than anybody else. So this law that was being introduced as neutral was actually in a way of trying to limit the speech of certain members of our society, because the government didn't feel comfortable in the way those organizations were conducting their advocacy. And I think that the reason why that is now becoming an area of government concern is that certain conversations that we are now having have been politicized, right? So even wearing a mask is now a political statement. Getting a vaccine is a political statement. Supporting climate change is a political statement. So, it does really expand the scope of censorship. So I think there is a real balance to be struck between exposing certain behaviors online, at the same time ensuring that people have the privacy or some protection to really express strong disagreement, extremely strong disagreement, particularly with government or government officials. So I don't know how we strike that balance, but I think it should be a real concern that these laws can be used. On the one hand, they introduce as preventing trolling, but they can really be used to expose activists and others online.
Yeah, and even as I was talking about this earlier, I had the same view and thought to even make that comment. So I really like the question posed there, because I think to me, again, it's about ensuring we have safeguards in place, and a couple of steps to that. The first is safeguards. If there was an unmasking power within vilification law, for instance, the Victorian Equal Opportunity and Human Rights Commission, then having safeguards around how that can be used and when that can be used to mitigate some of the issues that Nyadol's just talked about, although I appreciate that they would never mitigate all of those issues, but some safeguards there. And I think, again, some of that is in Fiona's bill and we can always go further. The other side of things is we need better privacy laws. I think if there's anything we've seen in this last week, we need better privacy laws. And again, it's the point I was making about leveling up. I think we need to try and think of these two systems of laws as working together rather than against each other. So rather than saying a vilification law that unmasks an anonymous troll who's abusing someone is in contrast to privacy protections for people to remain anonymous online, is we use the two laws together to set the marker where that can be unmasked. And so that should not be in a common instance. It should be in a very rare instance, as it is in Fiona's bill, where either a serious criminal offence has taken place or there's a particular access to a civil remedy needed that requires the unmasking. And maybe it can be done in a particular way that it's only unmasked for the purposes internal to the case and the case is still suppressed, maybe in terms of the party names. We have existing mechanisms, some of which work well and some of which don't, to suppress party names and information that can be provided publicly, but allow the case to proceed. Because my biggest concern is also victims of domestic violence and the ways in which, any unmasking of anything, and I include the Optus situation within that, can be used, against them in those particular situations. And I've no doubt that may well happen from the Optus leak as well. Not leak, hack. So I think as long as we've got strong safeguards within vilification law, but at the same time we improve privacy protections and try and get them to work together, that'll mitigate some of the issues. But I have that concern as well. And I don't think that's a perfect answer. And I think we need, proper investigation into what that looks like if we're going to move ahead with that sort of power.
And another question is to do with different types of anti-vilification laws. So we have civil laws on the one hand and criminal offences on the other hand. And which do you see as more appropriate? Like, should it be that the targets of vilification should be the ones bringing their own action and seeking remedies, like whether it's damages or injunctions or something like that? Or should it be exclusively regulated by the police as a criminal offence? Or is both necessary? Or which is the most important types of anti-vilification laws?
To me, I think about vilification much like I think about discrimination as potentially trying to achieve three different aims. So one is prevention before it even occurs. The second is redress for those to whom it has occurred and they're seeking compensation for the harms they've suffered. And the third is some sort of deterrent or punishment effect for more serious situations of vilification. And so I don't think this is something that should sit only within civil law, only within criminal law. I think it should sit within both, but I think we also need to go further. So the vilification laws we have in Australia offer a very limited right to redress, to compensation for particular instances of vilification that have already occurred. We've talked about how that can be improved, but that fits within the redress part. We have criminal laws too in some jurisdictions, or I think almost in all now, for serious instances of vilification. New South Wales is perhaps the most famous in terms of how they deal with it. And I don't see any reason necessarily to remove that for the most serious cases that meet a certain threshold that does require criminal intervention when it comes to ideas around deterrence and punishment, notwithstanding that criminal law maybe isn't the best tool for those things either, but maybe the best legal tool at least. But I also think we need to look at what we can do within law to the extent possible to prevent it occurring in the first place. And to me, there's nothing we have in our current systems that necessarily stop it from occurring, apart from just associated prevention from having redress schemes and having punishment schemes. So in our submission, which Bill you'll be aware of, from the Australian Discrimination Law Experts Group to the Victorian Inquiry on vilification, we proposed at least a consideration of a duty on online platforms to take all reasonable steps to ensure that communications on their platforms comply with vilification laws. So rather than a positive duty on employers, like we see increasingly now in the sexual harassment space, it would actually be a duty on these online platforms where we're seeing a significant number, if not the majority of instances of vilification now occurring, to mitigate against that and placing more of an onus on them. It's something we already do in defamation law. I mean, in our very, very strong defamation laws that, most people think should be weakened because they perhaps go too far that way, but there's already these rights that exist that are being imposed in regards to defamation. It makes no sense to me that we wouldn't impose such duties when it comes to vilification, since the victims of vilification usually have a totally different power dynamic to the victims of defamation. So to me, that would at least add that third prong to what the civil and criminal systems are already doing in this space.
Nyadol, do you have any comments about the balance between civil laws on the one hand and criminal laws on the other? Like, are one more important than the other, or
no? I think
both needed?
I think Liam covered that, so I don't have any answer.
No problem. So we have another question from the audience, and it's thank you to the host and the guest panelists for the wonderful insights. A question to the panel regarding the constant balance between competing rights and the need for action. For example, in Germany was provided earlier as a nation that was able to maintain the balance. Is there any other jurisdictions or countries we can look to? Are there any other jurisdictions that we can look to in terms of better models for anti-vilification laws?
None to me come to mind, but I also think that perhaps the way to think about it, and maybe the German example is a good one, is that how we address those questions are influenced by our history and the particular country history. And so we might not need to go necessarily as far as Germany has gone. And in fact, on my Twitter account, I put that I'm in Germany because I realized that if I do that, if I put my location as Germany, I receive less hate, because I think that the media companies are required to sort of do more work in terms of removing the racist abuse online than if I put my location as Australia. So I think the conversation that needs to occur of what are the kind of the historical issues in Australia. Some of them are going to be similar across the world in terms of treatment of the LGBTI communities, issues of racism generally. But then there are particular questions about Indigenous Australians as well, and how they experience vilification in this country. So I think whatever solutions we'll have can borrow from other countries, and it's useful to see what those countries are doing. But fundamentally, it's about answering how vilification look like from an Australian context. And this country prides itself as being the most multicultural society in the world, and I think that that might be a good thing, but being a multicultural, multi-religious, multiracial country asks very difficult questions of the systems that exist, because they have to respond to different needs of the community. And that to me it's not something new. I think politics always have to respond to different needs. That's why we have different political parties with different persuasions. But I think people find it very hard to attune their mind to thinking that that you could do that for other characteristics that are just not ideological as well. So yeah, it's a roundabout way of answering your question. I only know about Germany because I found it useful to be able to argue some of my points when advocating for the kind of what might look like the acceptable perimeters in this space of limiting hate speech and incitement. But but equally as well, I think the question is would be answered in response to particular issues in Australia, not just what other countries are doing.
And I think a difficulty we have is that some of the countries overseas that are perhaps recognised as doing quite well in this space are civil law countries, and so their ideas are really important, but our legal system is so different that it makes it challenging to translate identically. And then you add the cultural and societal differences, as Nyadol just talked about, and there's a lot of layers there and complexity to then translate it. So I think, again, we should use all those ideas and build from them, but it's hard to go copy and paste from any of those other countries. And I think for me, within Australia, there are two examples of laws that we can each use as a starting point. I still think the Racial Discrimination Act, Section 18C, notwithstanding all of the controversy over it, is a strong provision that does balance it because of the existence of 18D, which is never talked about in the media, ever. But everyone looks at 18C and goes, oh, the standard set is offence, and that's a really low standard, and that may well be the case. But the defences provided in 18D, particularly for matters in the public interest, are also really strong. So it's a lower bar with stronger exceptions for particular instances where we have decided for policy reasons to allow that speech to occur. So look, I'm not suggesting that the RDA is the best thing in the world on this at all. It has significant problems too, but it's a starting point, and I think a better starting point than where Victoria's laws have been. I think also, just to go back to it, often my answer is look at Tasmania. They're often one of the best jurisdictions in Australia for anything to do with discrimination or vilification law. Again, not perfect. Again, their tests perhaps could be adjusted along the lines I suggested earlier, along the lines that Fiona suggested too. But when you're at least prohibiting, 14 different attributes when it comes to vilification, you've got breadth. Some of the depth I still think needs to be answered in Tasmania, but they've got breadth there. And I think when you're covering that and you're saying to your society, you cannot vilify on the basis of someone's sexuality, on the basis of someone's gender, on the basis of someone's disability, you're making a clear standpoint and you're making a clear moral marker. How the law is used is a totally different question, and it's the thing that takes up so much of all of our time. But if you're setting that down as a first moral principle that you cannot vilify on that basis, it's a big first step to take. So they're the two jurisdictions I look at internally.
I did remember one country, Canada. Canada seems to be doing really well, and just not in terms of the legislation, but also in terms of like the the judicial responses to cases when they come to the courts. You know, it's very rare you get Australian judges that are willing to get into the messiness of talking about how do we delineate what is racism or racial profiling in a particular context. And I had a very good experience of that when during the race discrimination case that was brought by a number of African Australian young people against the Victorian police in the state of Victoria. And just the lack of, you know, judicial analysis that you could draw on to be able to argue some of these points. So we had to look at what was happening in Canada, and that was just so much more advanced and in terms of their thinking on these issues.
And it's very interesting that Canada is a country that's had a human rights charter for such a long time, and I think that it helps to inform the thinking of judges. And these issues about hate speech versus free speech have been debated for such a long time. And I think in Canada that they're actually getting into the nuances and, you know, that realizing that we have to balance two important things, that it's not one or the other, it's actually finding a balance. But we have reached time today, and I want to thank you so much, Liam. Thank you, Nyadol, for your time today. It's been such an amazing discussion, and I really want to thank you for your insights, and I think it's been really informative for the audience today. We've got audience members from New Zealand as well as from Australia, so it's been a cross-country experience, and I want to really thank you. And for everyone who's in the audience today, I just encourage you to join the Law and Society Association of Australia and New Zealand. If you haven't already, you can go straight to the website and join up very quickly, and you can enjoy great events in the future similar to this one. So thank you again, Liam. Thank you, Nyadol. It's been great to experience the benefit of your insights and your experience today. It's been a really informative discussion. So thank you very much for your time today, and I'll close the session now.